And today, the Justice Department is set to release new NSA-related documents. They were previously secret decisions of the Foreign Intelligence Surveillance Court. However, the information is finally going to be released today after a long-running FOIA request submitted by the ACLU and the Electronic Frontier Foundation. The civil liberties organizations had been seeking to learn just how the government has been interpreting one controversial provision of the Patriot Act that's thought to be responsible for justifying the NSA spying of ordinary Americans. And as more details emerge over the government's surveillance of user data, technology companies are beginning to escalate their efforts to publicly disclose information about what the government has coerced them to share. Yesterday, Yahoo and Facebook each filed a lawsuit in the secret Foreign Intelligence Surveillance Court, asking for permission to reveal the number and kinds of national security requests the companies have received. You may remember that tech companies Google and Microsoft filed similar lawsuits back in June. However, this week, both of those companies amended their petitions for permission to release even more information regarding the requests. So here to talk about these mounting tech lawsuits and the implications of the upcoming FOIA release, I'm joined by Elizabeth Goitein, co-director of the Liberty and National Security Program at the Brennan Center for Justice. Elizabeth, thank you so much for joining me. So these documents are going to be coming out today. We thought they would be coming out a little bit earlier. Unfortunately, they did not. But what can we expect to learn from them?
I think we will finally see the secret FISA court's rationale for approving bulk collection of all of Americans' telephone records. I think we've had a hint of what that rationale is because the Justice Department released a white paper back in August setting forth the government's legal justification for the program. Presumably what the court found is something along the lines of what the government put forward in that paper, but at least we'll have the chance to see how the court hopefully weighed some of the competing arguments about whether, in fact, every American's telephone records are relevant to an authorized foreign intelligence investigation.
Very, very important information. And Ron Wyden, who's been on top of this, back in 2011, he said this, quote, "When the American people find out how their government has secretly interpreted the Patriot Act, they will be stunned and they will be angry." What do you think he meant by that?
Well, I think he's right. I mean, I think that Americans now know that the government has interpreted this authority, which on its face looks fairly narrow. The government is allowed to obtain records from third parties like telephone companies if it has grounds to believe that those records are relevant to an authorized foreign intelligence or international terrorism investigation. And the government and the FISA court have interpreted this authority to allow bulk collection of all Americans' telephone records. That really doesn't look on its face consistent with what the statute allows. And so I think Americans were shocked to learn that their own telephone records are being treated as relevant for counterterrorism purposes.
Absolutely. Well, the ACLU filed their FOIA lawsuit shortly after Ron Wyden said that. And why, I wanted to get your take on why you think it's coming out now. Why 2 years later are we finally having these documents released?
A combination of reasons. Part of it is that the disclosures by Edward Snowden forced the government to try to get ahead of some of the additional disclosures that it knew were forthcoming. It had to try to spin what was coming out in its own way, or to put it in a nicer way, it legitimately wanted to explain maybe some of the authorities that had been released. And so it had to engage in its own series of disclosures that it otherwise would not have wanted to. But there's also the fact that the court in these FOIA cases, Freedom of Information cases, was putting pressure on the government and not buying the government's justification that everything had to stay classified without any review.
Sure. And do you think this is part now of a growing trend to see more sort of transparency within the FISA courts?
I think we'll see more transparency where transparency is necessary. I think the government's hand was forced in this case by the Snowden disclosures and by the courts in these FOIA cases. I think as long as the government's hand continues to be forced, we'll see more disclosures and more transparency. Otherwise, I think it's up in the air whether that will happen.
Sure. And many people defend the secrecy of the FISA courts by saying if you make it transparent, it means that they can't do their job accurately. What do you make of that argument?
Well, looking at the opinions that now have been disclosed, it's pretty clear that it is is possible to tease out some of the operational details that need to be kept secret, legitimately so, from some of the legal analysis that the public has a right to see. So I think that that principle should inform what the court does going forward.
Absolutely. And of course, now we know that 4 different tech companies, Facebook, Microsoft, Yahoo, and I'm slipping the last one, but they're all seeking permission to disclose information about how users are being spied on. Do you see this as a PR move, or do you think this could be real, basically elicit real substantive change?
Both. I mean, I think the companies have quite an incentive to try to burnish their own image as advocates of their customers' privacy. I think their image has been tainted by some of the revelations that they cooperated in some of the NSA's activities. But at the same time, these disclosures, if they are permitted, would be very important in terms of helping the public to understand what kind of surveillance is going on and how their own communications and transactions are being treated.
And do you think they will be, that these requests will be granted? Do you think it's likely?
I think it's possible they'll be granted, at least in part, and I say that because the Director of National Intelligence has, on his own, agreed to release some of the same information that the companies are seeking to release.
But even if, users did know the extent to which their data was being compromised, do you think that that would stop them from really using Facebook or Google, or do you think that we're too intertwined with these services, with these websites at this point to really back away and say, I won't take part in that anymore?
I think there are companies that might offer alternatives to consumers in this country, but I think really it's the international population that a lot of these companies are focused on, because they want to be able to market their services to people in Europe who are wary, who have different privacy standards, frankly, and are dismayed by what some of these companies have been doing in cooperation with the NSA. So I think, in a way, those are some of the markets that the companies are most concerned with.
And lastly, I want to get your take on something. We only have a minute left, but Apple just unveiled their latest iPhone, and it has this really, I don't know if you heard about it, it has this feature where you can sort of, now it scans your fingerprint, and that's how it identifies who you are. Obviously, a little problematic. I mean, do you think there will be pushback or should be pushback to that feature?
I assume
considering the relationship between Apple and the NSA.
I assume it's a voluntary feature, and I would hope that people are aware of their rights and also aware of some of the risks before they decide to scan their fingerprints.
Well said. Well, thank you so much for coming on. I really appreciate your time. Elizabeth Goitein, co-director of the Liberty and National Program at the Brennan Center for Justice. Thanks so much.
Thanks very much.